All right, so how much does it cost for you to get a patent? I know, the big question, right? And these days, right, it's all about the credit card, not cash. But do you know what? People always ask this question, and it's normally the number one question I get. So I wrote a blog article about it, but I want to get to the bottom of this, right? What is really involved and what does it mean? Before I jump to my legal explanation, the answer is $700 to $40,000. That's the range. Okay, not happy with the answer? Well, keep listening, okay? And as we go, I want you to like or comment or subscribe, ask me the tough questions as we keep going through this video, because I want you to have the answers you deserve. You've dedicated time to come here and listen to this video. And if you're still listening, you're right there with me, okay? You are demanding. You're an entrepreneur. You're a visionary. You're an inventor. Someone who's gonna make a difference in this world. And that's why I do these videos. That's why I write the blog article that I did. And below, you're gonna see the table of contents, a way for you to fast forward, to rewind, to get to exactly the part of the video where you're gonna gain the most information. Now, if you're a go-getter and you got a full 7, 8, 9, 10 minutes, listen to the whole thing. I promise I'm gonna deliver value to you to make sure that you've got the best info possible. So let's get to it. I'm JD Houvener, patent attorney and owner at Bold Patents Law Firm. I have dedicated my career to you, the inventor, to making sure that you have the best information and legal advice on how to move your product to market to return on investment that you're looking for. My job is to make sure I come here and educate and consult and advise you to make sure you have everything you need to protect that invention that you've worked so hard for, and to make sure you get that legal right, that federally backed 20-year monopoly that you deserve so much. So today's blog article is all about how much does a patent cost, right? We talked about this huge range of $750 to 40 grand. Let's break that down and unpack what that means. It starts out with an understanding of what your time is worth as the inventor, an entrepreneur, and business owner, and what my time is worth. Your time is critically valuable. The amount of time you spend working on your patent is time that you could have spent, for example, on your invention and on building your business. Okay, that's vital to understand that you're hiring a professional, a patent attorney, to take this load off of your shoulders and to let us do each step of the process to help make sure that your invention is protected. Step one is the patent search. You can't leave this part out. I've talked about it before. Here's a link to the video for how to get more information on a 6-step process on how to move your patent searching process forward. All right, so now I'm talking about this first investment of time, which is money, in conducting this diligence and hiring a professional patent attorney to conduct a search and deliver to you a legal opinion on whether they think you should move forward to the next level. You see, you don't need to think about the cost in terms of this $40,000 plus dollar amount, which is really true in how much you would spend over the course of a few years if you move forward in the right way. But know that if you take it step by step, it's bite-sized chunks, all right? And the search can be done for as little as hundreds of dollars, all right? But to do it right and to get a legal opinion, it's gonna take some time. And the range there is gonna depend largely with how complex your invention is. We don't, at least at Bold Patents, we don't think of all inventions as being the same. I mean, that's silly, right? We're not gonna charge one fee no matter what invention you bring forward. This book is available for free at boldip.com/free. And I want you to have your own digital copy, a PDF download today. So go visit the website. This book walks you through what it means to conduct a patent search, how to do one on your own, at least preliminarily, and knowing when it's right time to move your invention into the hands of a professional patent attorney to conduct this first step. So the real key to understanding cost is to really understand the whole process of what it means to move forward with your patent application. The patent search we just talked about. So let's assume at the outcome of that search that it's patentable. We're now going to move forward to the next phase, which is either a provisional or a non-provisional patent application. The costs there are different too, okay? A provisional application takes about half as much work. The specification, which is the written description, writing about what the invention is, as well as the drawings, that's all very informal. And therefore it costs half as much money as it would to be for the non-provisional. That's the full formal patent application. Again, check out the Bold Patents book for more information about that. If you're enjoying this content, give us a like, Share this video with someone that you may know on your social network. This is the time to pay it forward, right? If you're getting good, valuable information in this video, let us know. If you don't like the content, let me know too. I need to make sure I'm moving forward myself and relaying this information perfectly to you, my audience. How much money is it really going to cost at the provisional phase, right? So you've spent, what could be $2,000, $3,000, $5,000 on this patentability search and legal opinion. That all is going to be investment toward understanding when and how to approach this provisional or non-provisional patent application. So let's take the provisional, which is half as much effort, okay? Typically between $5,000 and $10,000 to file a provisional patent application. That's the legal work it takes. That's the time and effort for a patent attorney to really conduct that level of effort to move your innovation to the written form and the legal definition. One of the interesting facets that most inventors don't understand when they get started is that when you bring in an invention, right, you start describing what it is you've created to a patent attorney, we're taking notes and we understand and appreciate what you're talking about, but we know that your invention is likely much broader than what you're disclosing. This one vision that you have in what the product will be in your consumer's hands actually can take the form of lots of different materials and could have other benefits and applications outside of the industry that you're first discussing. So it's our job in that provisional and eventually the non-provisional to expand the scope of your invention, to really help you think about what you've really created and think about all those different what's called alternative embodiments. Lay them out clearly in technical and legal language to make sure that it's there as the palette, right, that will be later drawn from to paint that beautiful picture of your non-provisional claim set that will become later. That first investment in the search, now the provisional, okay, now we're talking $5,000 to $10,000, and now the non-provisional, another investment of $5,000 to $10,000. As you've seen in my other videos, it's a year-long investment of time. When you file that provisional, you have a full year when you must file the non-provisional. That amount of time is when you should be hitting the market, sharing your product with trade industry journals, talking with licensees, and prototyping it. Getting that information and improvements so you can iterate quickly to know what exactly you're going to be claiming in the non-provisional. So the amount of work in the non-provisional is formalizing the spec, formalizing the drawings, and drafting that all-important claim set, okay? Usually 1 to 20 claims. 20 is pretty standard. 2 to 3 independent claims, identifying an apparatus if possible, a system, or a method. All right, so this is the heart of patenting. This is what will be examined by the USPTO patent examiner once the application is submitted. This work is really the upfront searching and application process, anywhere between $5,000 and $20,000, okay, depending on the complexity. On the low end would be something more like a mechanical device, like a utensil, a kitchen device, a consumer product, or on the more complex side, something like a computer method, right? A computerized business method that's going to take a lot of words to describe the inputs and outputs and the benefits and functionality. So you can start to gain an appreciation for the level of complexity, and that's what will drive the cost in terms of how much searching, how much application drafting is going to be involved along the way. Once you submit the non-provisional, there is multiple steps, right? There are going to be what's considered office actions after you submit. So the examiner is going to review that application that you drafted so carefully, and they're going to do their own search to cover worldwide patents and non-patent literature. So it could be the examiner finds the same thing you found, but looks at it a little differently. Or the examiner may look at it and say, gosh, I think this is actually part of the prior art and you didn't think it was. What you're claiming has already been done in part over here. And they're going to cite that other reference. Now it's your job, or rather the patent attorney's job, to argue on your behalf, to be your advocate, to provide legal argument and amendments to get around that prior art to make sure your patent gets issued. So I say in general, figure between 2 and 3 of those office actions to make sure we get you the broadest patent possible. So again, that could be upwards of $5,000, maybe even $10,000 worth of legal work to get those office actions handled. So that's why this big range, right? That it could be the case that there's no office actions at all and it sails through the patent office. There are some reasons, and some attorneys, including myself, that might think, maybe we didn't claim broadly enough if it just sails right through. But that's neither here nor there. I just wanted to make sure you understand and appreciate that there are a lot of varieties here, variables at play in terms of what goes into the work for every single invention. So glad you made it here today to discuss how much does a patent cost. And don't worry, it's not going to be this huge chunk of money that you're going to be out, all the money immediately. You're going to take this one step at a time. We're there by your side so you can make a business decision to support your innovation on the way. I'm JD Houvener, patent attorney, USPTO registered attorney for Bold Patents. I'm so excited to share this content. If you found it valuable, please give us a like, share it, and give us some comments and feedback about how we did today. Have a great day, everybody. Go big, go bold.